we start with item 7, which is an informational item on draft procedures for conducting a removal proceeding pursuant to Section 412.5 of the San Mateo County Charter. This item comes from the county attorney, and I'll ask Mr. Nilvin to introduce it.
Thank you, Mr. President. I wanted to say a few things by way of preface, and then I'm going to hand the mic over. So Measure A, as has been noted in certainly prior conversations before this board, has approved an amendment, a revision to the San Mateo County Charter, and specifically it adds Section 412.5 to the county charter, which provides for the board to have authority to remove the county sheriff for cause. Section 412.5C of the charter, as amended, provides that the Board of Supervisors itself may provide for procedures by which a removal proceeding pursuant to Section 412.5 shall be conducted. It's been noted that on the consent agenda today, the elections officer has certified the election for Measure A, and that the board has approved the election results in Measure A. And as has also been noted by a public commenter earlier today, these results will be lodged with the Secretary of State, and then in 10 days from the date of board action, this charter amendment, Section 412.5, will become effective. Today's action is not an action item. The board's not going to be asked to vote to approve procedures, but we did think that in this interim time before the charter amendment becomes effective, it would be appropriate for the board to have the opportunity, and frankly for the public to have the opportunity to see what procedures staff is proposing at this point for the board's consideration, and that we would have the opportunity to receive feedback from the Board of Supervisors after the board has heard public comment on these draft procedures. As the memorandum that accompanies this resolution notes, the law firm of Hanson Bridget LLP has been retained by staff to work on putting together a draft for the board's consideration. And specifically, we have Mr. Alfonso Estrada, who is a partner with Hanson Bridget, who has had the laboring oar on this, again, for resource purposes, and frankly, the fact that we're walking down a road that we haven't, that no county has walked down before. We thought it was appropriate to work with Hanson Bridget on all of this. So by way of preface, I'm going to go ahead and ask Mr. Estrada to join us via Zoom. He's a new father, and so he wasn't able to travel up from Los Angeles to be with us in person today, but he's available on Zoom, and I'm going to ask him to offer you a brief presentation on the work he's done, and so that we have, the opportunity to hear your feedback and to hear from the public. Thank you.
Okay, can everybody hear me okay?
Yes.
Yes.
Okay, all right, so I'm gonna share my screen and show you all a PowerPoint we prepared for today's presentation. Give me one moment. Okay, due to the ordinance that was passed in the beginning of March by the county by a pretty overwhelming majority, we were tasked with drafting procedures for how to conduct the removal proceeding that's been authorized by San Mateo County Charter Section 412.5. There is the specific language from 412.5 and specifically subsection C, which calls for the Board of Supervisors and that they may provide procedures by which a removal proceeding pursuant to this section shall be conducted. We got to work in looking first at 412.5, what it dictates and requires, and then we developed a pretty robust review procedure. Just kind of before getting into the specific steps, the emphasis on it was to be, to encourage impartiality throughout the process, and also just fundamental fairness to both sides, the sheriff and the county. So here's a overarching kind of bird's eye view of what's entailed. First, in order for the board to initiate the removal procedure, they have to act by a 4/5 vote to start the process. Once that process is started, A notice of intent to remove, it's a written document, will be prepared for the purpose of presenting that to the sheriff and her authorized representative. And thereafter, within 5 days of its issuance, there'll be a pre-removal conference where the sheriff will have an opportunity to appear and respond to the allegations that are detailed within the notice of intent to remove. So that's moving from step 2 to step 3. After the pre-removal conference, which will be presided over by a pre-removal conference officer, they will give a recommendation to the board, and then the board again will convene and, by a required 4/5 approval, issue a final notice of decision. After that occurs, then there'll be the opportunity for the sheriff to submit a removal hearing request, requesting a full evidentiary hearing occur. After that step occurs, then there'll be a separate process, step number 6, of a hearing officer being selected to preside over the removal hearing, which is the evidentiary portion of the hearing process. That will be step number 7, and the hearing officer will preside over that in the capacity as a hearing officer or arbitrator to some extent. Then we'll move to step number 8. At the conclusion of evidence and closing arguments, then the hearing officer will issue an opinion, which will go to the Board of Supervisors, and they'll have the opportunity to review that opinion and the administrative record from the hearing and issue their final decision, which again will require an independent 4/5 vote in order to approve and either remove the sheriff or not. Getting into kind of a flow chart here, which I think is a little bit more visual. The first step again would be the board convening and voting by a 4/5 requirement under 412.5 and development of the notice of intent. Thereafter, it'll move to the pre-removal conference where the sheriff gets that opportunity to appear and respond to the charges. Step number 3, the board gets the recommendation from the pre-removal conference officer, and then they will again independently vote. And if 4/5 of the vote is obtained, it'll become final. The sheriff at that point will have the opportunity to request a full evidentiary removal hearing. They'll also be issued the hearing officer list, and the two parties will meet and strike from that list until they arrive at the selection of a hearing officer, which is step 5. Pretty quickly after the hearing officer will be selected, there'll be some initial discovery, initial disclosures, and a time period in which both parties have to meet and confer and resolve any discovery disputes before moving forward with the hearing. Thereafter, the removal hearing will begin, step number 9. And at the end of that, we get the opinion of the hearing officer. Again, the board will review it. And then 12, they'll issue their final vote, whether or not to remove the sheriff. Again, by charter section 412.5, a 4/5 vote will be required to make that decision final. So there's 3 separate occasions within this process that we've constructed that will require the vote of the board by a 4/5, 4 out of 5 requirement per the actual language of the ordinance. We anticipate, going back to this slide, we anticipate the total time for this procedure will be 3.5 months. And the reason it is so robust is to ensure the sheriff is afforded due process, and at the same time that the county is afforded due process, and that this all be done efficiently and as quickly as feasible, given the need for the sheriff's department and their operations to be managed appropriately. A little bit more on the removal hearing. It'll be open to the public unless objected to specifically by the sheriff. It'll be informal in nature, not governed by rules outside of those set forth in the removal procedures. Okay, so not as if you would be in a under the evidence code strictly. No, these are all taken into account in the removal procedures that we have set up. Separately, each side will have up to 5 days to present their case, 10 days total. There'll be a more narrow and limited discovery And then also the hearing officer will be empowered to issue administrative subpoenas as requested by the parties at the discretion of the hearing officer. So that is a kind of a summary of the process. Both parties will be presented with the removal procedure rules, which will govern this removal proceeding. So that's all I had prepared for today. I wanted to open it up for questions if anybody had.
Thank you, Mr. Strada. I'm going to go ahead and turn it back over to the board president for any questions or comments. Mr. Strada, I'll ask you to stand by in case there are questions we want to round to you.
Great. Are there any questions or comments from my colleagues?
Through the chair, I just want to say thank you for this update. This has been, before us for some time now. It is a huge concern to the community about timing, so I'm glad that we were able to provide this update and want to make sure that we continue to be as clear as possible of the procedures and what's going to happen moving forward. Can we go back to the slide where it talks about the boxes?
So, Mr. Strada, maybe I'll ask you to go back to your flow chart.
Yep.
And there were two different slides, I think, with maybe let's start with the first one,
okay.
part one.
So walking through this, box one, have we already gone through box one?
No, Supervisor. In fact, what we anticipate is that after today's proceedings, and we have the opportunity again to hear from you and to hear from the public and ultimately get direction, we'll come back at a future board meeting for actual adoption of these procedures, and there won't be any action taken on anything reflected in any of these boxes until you actually adopt the procedures. So that's a step yet to come.
All right, thank you.
Yes, Supervisor.
Are there any additional questions? Supervisor Corso.
Thank you. I have a couple of questions, maybe more than a couple, to be honest, that I think are important just for the sake of clarity and for the community to really understand kind of the details of how this will work. So would you be able to share who would be participating in the pre-removal conference?
Certainly. So the pre-removal conference will be that first opportunity for the sheriff to appear. So it'll definitely be the sheriff and/or her authorized representative. The removal procedures, as we've constructed them, call for the assistant county executive or their designee to appear as the pre-removal conference officer. And then the county will be there through their representative as well. So that is what's contemplated as far as folks will be present for the pre-removal conference.
Thank you. And this would be private, correct?
Yes, this is not contemplated to be a public portion of the hearing. That comes in the removal hearing, which comes after, unless if the parties specifically agreed to it otherwise. But that's contemplated to be between the initial parties I described.
Thank you. And for the sheriff, for 4A, the removal hearing. Oh, wait. I think so. No, I'm confused. For the removal hearing, when it happens, it would be public unless the sheriff specifically requests that it's private, and then that would make it private, regardless of how the board or the county.
That's true. If the sheriff requested it be closed, it will be closed.
Yes, that is correct.
Thank you.
And that's step number 9, Supervisor, that you're describing.
Oh, yes. Thank you. And what are opportunities for the public to provide input in the pre-removal process?
Well, there'll be lots of opportunities, including as the county's attorney just described. In order to even initiate this process, right, that'll have to come before the board, and there'll be a 4/5 vote. So initially, that'll be agendized, step number 1, right, and that'll be something that the public can comment on. Thereafter, for the board to take any action, right, they will have to do it by a 4/5 vote, which will also be noticed. But really, these procedures were built for step number 9, which you referenced initially, Madam Supervisor, And that, barring any objection from the sheriff, is contemplated to be a hearing that will be open to the public, for the public to be able to attend even if they wish to. So we were intentional about including that, part of the procedures to invite the public into the actual proceeding.
But as was noted by Mr. Estrada, there are a number of junctures where the board would have to act in a public meeting by way of a vote, and those will be opportunities for the public to be heard with respect to these matters.
Thank you, and I also just want to add to that that the public can provide input on these potential procedures, I believe, in this meeting, and then directly to the board for the coming weeks until further action is taken, correct?
That's true, Supervisor. I mean, again, we can hear from the public today, and we're hoping to, and there will be some passage of time between now and whatever time it is the board ultimately acts, and will, any comments received during that time period will certainly have the opportunity, and the board will have the opportunity to consider before the board takes final action.
Thank you. And then we heard a public comment earlier today sharing some concern about whether we are able to move forward because of something that needs to be filed at the Secretary of State?
Yes, Supervisor. I think the gist of the comment was that we were acting prematurely because the charter amendment only becomes final and effective after it's lodged with the Secretary of State, and actually 10 days after the board took action to approve the vote, which it did today. I'd note that today the board is not being asked to take action. In fact, what the board's being asked to do is provide input. So I think it's appropriate and safe for us to wait until the charter amendment actually becomes effective before the board takes action to approve these procedures. But I don't see any legal problem with the board engaging in the process we're engaged in today.
Thank you. And then the process that's being proposed, to what standard will it be held? For example, does it have to be held to the same standards as a courtroom?
Thank you for that question. It's a preponderance of evidence standard, and as has been in a preponderance of evidence standard is that it's more likely than not, the evidence shows that it's more likely than not that something occurred, or that it's more likely than not that this proposition can be supported. So it's a preponderance of evidence standard, which is a common civil standard.
Yeah,
Thank you. Go ahead, Mr. Estrada.
Oh, just wanted to add, it's the default in these types of administrative proceedings. Preponderance of the evidence is the standard, the default standard.
Thank you. And then what guardrails are being proposed to trust the testimony that's going to be given to the hearing officer?
I'll ask Mr. Estrada to grab that.
Sure. Excellent question. And every witness who testifies in the removal hearing will do so under oath or affirmation. So that will be the same as if they were in a court of law in front of a jury.
Thank you. And what would the outcome be if someone who is subpoenaed or invited to participate in the hearing or provide testimony, what happens if they choose not to? That would be ultimately for the hearing officer to decide. There are specific provisions that have been built into the procedures that afford the hearing officer discretion on what to do. But one of the remedies that could potentially be issued would to draw a negative inference possibly against the individual for failure to show. But ultimately that's going to be the hearing officer's decision to make. And the procedures vest them with that independent discretion because we want these procedures and this removal process to be impartial. So that is the mechanism that's been built into the process. Thank you. And then my final question, what is the soonest possible timeline that this can be completed in? And then maybe a more realistic timeline, and what's the longest?
Again, timeliness and efficiency was one of the main things that we were tasked with in developing these removal procedures. So As I think one of the final slides stated, the total estimated time would be 3.5 months. Realistically, there's some wiggle room within the procedures that if folks are a little bit more timely and maybe don't take up all of the time required for discovery and other things, it might be a little bit quicker than that. But I think 3.5 months is a pretty accurate assessment given the procedures that we've built.
Thank you.
Mr. Mueller. Okay, great. Are there any other questions? I'll just make a comment and then I have questions for Mr. Estrada. I want to just make it crystal clear today to the public that the board will not be initiating removal procedures today, as this is an informational item only and no action will be taken on this item. Is that correct, Mr. Estrada?
That is my understanding.
Thank you, Mr. Estrada. We are merely considering providing direction to staff and seeking community feedback on how the removal proceedings may be conducted moving forward. The earliest the board may approve the final removal procedures will be April 22nd. Is that correct, Mr. Estrada?
Actually, maybe I should take that just because it's a matter of board governance. Again, absent a special meeting, that's the soonest the board could consider the item.
Okay. Thank you so much, Mr. Niblin. Then if a board approves final removal procedures with a 4/5 vote, it will trigger a series of actions that board will take to notify the sheriff of the intent to remove and then to allow the sheriff to respond to the allegations. Is that correct, Mr. Niblin?
That is correct. If the board were to approve a notice of intent, which is the initiation stage, assuming, again, these procedures are adopted.
Great. As president of the board, I want to ensure the public that this will be a measured and transparent process that will be fair to the sheriff, who deserves due process. I do have questions related to Attachment A that Hans and Bridget presented related to pre-removal conference. The language indicates that the assistant county executive or their designee will preside over the conference, which allows for an opportunity to respond to the allegations against the sheriff. When we say assistant county executive, who are we talking about? And will the designee be, if we go that direction, be appointed by the assistant county executive or this board?
We were specifically referring to the current and present assistant county executive, Ms. Rodriguez, or a designee that she would designate if, in fact, there was a need to designate someone else. I don't think that was the contemplation, but that's the way the language is structured. And of course, this is, again, at this stage, draft, and the board has the discretion ultimately to decide maybe a different direction is warranted in terms of who presides over that process.
Yeah. I'm asking because I want to make sure that there's absolutely no conflicts of interest in any way when these proceedings are conducted. And so I do have a couple suggestions.
Yes, Mr. President.
I do think we should look at some of the constitutional officers within our organization. That would be the tax treasurer, John Keene, who's
Yes.
our chief probation officer, Mark Church, who is our assessor elections. I really want to make sure that as we move forward with this process, I know we're all prioritizing objectivity, but I think those folks should be considered. I do think, my understanding through county council, Chief Keene is not appointed by the county executive, nor is he appointed by the Board of Supervisors. Is that correct?
That's true. That appointment comes through the courts, in fact.
Courts. Are there on the different departments that I had mentioned? How are they appointed, or are they elected offices?
The two you mentioned, the treasurer, the controller, or the assessor, those are all under either the Constitution or our charter elected positions.
As we move forward, I think we should really see, one, I guess, if there's interest from those who want to serve in that capacity. I think it's going to be critical as we move forward to ensure that this process, and I'm committed to it as the board president, making sure, and we all are, making sure that it's fair. And so what I would direct county council to do, or county attorney, is I suggest reaching out to probation chief Keene to see if there's potential interest because of his relationship with the court.
Yes, Mr. President. I'm actually going to shoot for willingness. I don't know. Interest may be too much to ask for, but a willingness I can certainly run that down, and I certainly understand, and I think it's a very worthy suggestion. So we'll work on that.
Thank you so much. Are there any additional comments or questions? Yes.
I'd like to just add that I think that's a really good idea to consider someone else that is also a constitutional officer. And I know you mentioned our treasurer as well, Sandy Arnott. I think it'd be maybe a good idea. I actually think Chief Keene is better positioned because he's appointed by the courts, and we want this to be, I think that's a helpful skill set to have in something like this.
Thank you, Supervisor. We'll definitely take that under advisement and work on it.
Thank you.
And let me just say this through the county attorney. I think Chief Keene, my understanding of Chief Keene is his background is in law enforcement. I think his background working with the courts may put him in the position to have judgment relative to this matter. And I think Supervisor Corzo's right. We're lucky to have, Sandy Arnott. So there are well-qualified candidates amongst this organization that serve as either elected appointment heads or appointed by the court. And so with that, why don't we take public comment?
Thank you, Mr. President. I do have several speakers from chambers, and then we'll take speakers from Zoom. We'll start with Deacon Lauren McCombs, followed by Nancy Goodman.
Good morning to all present. We're still mourning. We've made it this far. My name is Deacon Lauren Patton McCombs. I'm currently serving at Christ Episcopal Church, Portola Valley and Woodside. I'm a member of the Peninsula Solidarity Cohort. On April 3rd, San Mateo County votes were certified, and the residents of San Mateo County overwhelmingly approved Measure A. I encourage the board to act quickly to vote to remove Sheriff Corpus. Measure A has empowered the 5 of you with the ability to do so. This isn't a time to move slowly. It's obvious that the public, as well as our sheriff's deputies, no longer have faith in Sheriff Corpus' ability to lead the sheriff's department. I am hopeful that the board will take the necessary actions to reestablish communication, transparency, and accountability within the sheriff's office. Our county is at an important crossroads to move forward in a positive way. I have faith that collectively we can do so. My thoughts and prayers are with each one of you for your time and leadership in serving our county. Thank you so much.
Thank you, Reverend McCombs.
Thank you. Next is Nancy Goodman, followed by Thomas Mizuko.
Thank you, and thank you to all of you for taking on this important and difficult task and for coming up with the draft procedures. I'm Nancy Goodman. I live in Redwood City. I'm with Fix in San Mateo County. My only recommendation of change to consider on the draft procedures is to require under Step 9 that the removal hearing be public, not let the sheriff quash that. And I say that because 84% of the voters in the county voted for Measure A, which was advertised on their billboards as remove the sheriff. So to leave us out of the removal hearing doesn't seem consistent with the vote. And secondly, just really expedite it. For the sake of the people who work in the office, they are working in a toxic work environment. They deserve better. They need a healthy work environment. That makes for healthier actions in our community. We also need, as soon as possible, a fully functioning sheriff office in case of any public safety emergency. And finally, just try to remember to put guardrails in place as you go through this process so it doesn't happen again. Thank you so much. We're with you on this.
Thank you. Thomas Mizuko, followed by Christopher Ulrich.
Thank you, members of the Board of Supervisors and County Executive Calgi, Mr. Niblin, and Ms. Rodriguez. I'm Thomas Mizuko, and I'm counsel for Sheriff Christina Corpus. And it's terrible to give an attorney a 1-minute rule, but I'll go try as best I can. We do agree with Mr. Estrada from Hanson Bridget that there should be impartiality and fairness, and there should be process. There should be due process. And one of our concerns is, just starting with the very name of this, about this issue that we're dealing with right now, sheriff removal process. That infers that there's already a preconceived determination that sheriff will be removed. And why are we concerned about that? Because unfortunately, we're concerned about whether this board can give a fair and impartial vote on the different periods of the process based upon unfortunate, very public statements where judgment has already been made about Sheriff Corpus, about she's a liar, she should be removed, without knowing the facts. Purely premised upon hearsay, a report from Judge Cordell that we have a judge looked at.
Continue, Mr. Musico.
Thank you.
Go ahead.
That's torn it apart. It has no evidentiary value. They're not sworn interviews. They're not tape recorded interviews. There's no methodology as to who was interviewed. We don't know who she interviewed. We're in the dark. There was also serious mistakes that Judge Cordell has admitted to. We need an opportunity to meet with those folks. We need to have them testify under oath. And those are things, all the unfairness that's been happening. And so we know that there's been statements by this board. We know that there's statements that this board thought were private that we do know about now. And so we're very concerned about the fairness and impartiality of this board. It's all based upon Judge Cordell's report, which is just has no evidentiary value whatsoever. Coming from me, a 30-plus year attorney, a former federal and state prosecutor, and former police commissioner, it's useless. So we wonder about that and
Can
the
you wrap up,
bias
Mr.
involved.
Mizuko?
So what we're asking for, we will meet with counsel, Mr. Niblin, and we'll meet with counsel from Hanson Bridget, and we'll work on what we think would be fair. But one thing we have to do is a lot of what's governed here is under the Police Officers' Bill of Rights. Sheriff Corpus falls under Government Code Section 3301 through 33013, which are constitutional rights she has that nobody will take away because we'll go to the other branch of government, the courts. And by the way, just one correction, these hearings are automatically closed unless the sheriff chooses to open them under POBAR. Also, there's not a default position for burden of proof to preponderance. That's a default. It's clear and convincing to take away a constitutional office. Thank you.
Thank you. The next speaker is Christopher Ulrich, followed by Matthew Fraunfeld.
Good morning. My name is Christopher Ulrich. I am also Sheriff Corpus's counsel. I urge the unbiased members of this board to reject the procedural rules that do not amount to due process. There are two issues that I'll address in my 60 seconds. The first is that, and we give credit to Mr. Estrada, it's clear that he's trying to create due process. Unfortunately, the ordinance that he was provided, the county amendment, does not permit for that. So what we have here is a board who initiates the action, their allegations. They then get it confirmed, or a hearing officer weighs in, and the board then reaffirms its own initial allegations. Then the appeal goes back to the same board for that board to render opinion. That is not an acceptable procedure, and that is what the limits were placed on Mr. Estrada by the structure of the county government. The second and equally important issue is two supervisors have already made up their minds. They told you how they would vote. Supervisors Corzo and Mueller have already told us. I'd like to ask you, would a fair-minded supervisor support a system where the accusers also serve as the judges, where an appeal goes back to the people who originally brought the allegations? Protect your integrity and the county's reputation.
Let's wrap up.
No court will uphold these procedures. Demand a process that separates accusation from judgment and accuser from judge.
Thank you.
Thank you. Our last speaker from Chambers is Matthew Fraunfeld.
Good morning, supervisors and colleagues. My name is Matthew Fraunfeld from Murphy, Pearson, Bradley, and Feeney, also counsel for Sheriff Corpus. I'm here to raise a serious legal concern with the structure of these proposed removal procedures. I echo the concerns of my co-counsel, as well as you have raised yourself, about the appointment of an unelected official in the pre-removal conference. This is an issue that stacks the deck against the sheriff before the process even starts. This is not due process. This is one side picking its own referee before the game begins. This injects bias into the entire process and risks shaping the board's decision before the facts are fully aired. This is especially true when the board acts as the initiating body and the final decision maker. If the goal of this is a fair and defensible process, no findings or recommendations should be made until after the sheriff has a full and impartial hearing. Anything less raises due process concerns and undermines the legitimacy of the entire proceeding. This structure invites the perception the outcome is predetermined. And that undermines the public trust. And then these procedures create the risk the elected sheriff will act less independently, worried about political retaliation rather than public safety. Thank you.
Thank you very much.
Thank you. No additional comments from chambers, so Madam Clerk, please proceed.
Public and Zoom, we're now on item 7 as a reminder. 3 hands raised. Dan Stejink, followed by Mark. Dan, please unmute and begin.
Through the clerk, this will be the last call for speakers online.
Okay, thank you, Mr. President. Those on Zoom, if you wish to comment for this item number 7 on the draft procedures for a removal, please click raise hand at this time. I will announce the final name that we will take on Zoom after this next speaker, and that will be the last name that we accept from Zoom. So Dan, go ahead and begin.
Thank you. My name is Dan Stejink. I disagree with the good county council on whether or not it's timely to take action on this issue for the simple reason that the results have not been received by Secretary of State at this moment. And had this not passed, we would not even be discussing this. I disagree with Attorney Estrada on the evidentiary requirement here. He said it's the default for a court. Preponderance evidence is default for civil court. Beyond reasonable doubt is default for criminal court, but clear and convincing is the evidentiary requirement for removing a constitutional officer. I disagree with item 3, the assistant county executive presiding over the issue. They are a direct report, as are the deputy county executives. County Executive Mike Callaghan, who with all due respect, has a current lawsuit against the sheriff for $10.5 million, being represented by Jim Hartnett, the leader of the recall group, whose previous court experience appears to consist solely of defending Popeye's chicken against a woman in a wheelchair. I also agree with item 6 that upon receipt of a timely proposal, the board will propose to the sheriff a list of at least 3 neutral hearing officers. This should really go out of county and go to former state judges on there. And I also suggest that that the sheriff have a 6th Amendment right to confront her accusers. Thank you very much.
Thank you, Dan. Through the president, a last call has been made to raise your hand in Zoom. And so the final 4 speakers at this time will be Mark, Jaime Clemente, 52FGK9, and an iPhone. Mark, please unmute and begin. Mark, please unmute your microphone. Mark's iPad.
Okay, there we go. Can you hear me?
Thank you. Yes, thank you.
Okay. Yeah, I'm simply concerned about the precedent this process may create and the message it will send to future elected county sheriffs and other elected officials in our county. And also, having read through the report by Judge Cordell, at the very end of it, I believe she said, well, there were no laws broken, but she supports the removal of the existing sheriff, and that seemed a little strange to me. So I hope we're not violating any constitutional rights for the sheriff or anyone else in this county here. Thank you.
Thank you. Next, we have Jamie or Jaime Clemente, followed by 52FGK9. Jaime or Jamie, please unmute and begin.
Hi, thank you, Board of Supervisors, for allowing me to speak. This is James Johnson, Redwood City. Been in Redwood City for roughly about 40 years. I do think that this format lacks neutral adjudication, and the hearing officer is not guaranteed to be impartial. Yeah, moreover, the subject of constitutional elected official to a quasi-judicial removal without due process protections is in direct conflict with Goldberg versus Kelly 1970, which sets a bad standard for administrative due process. Just based off of what Alfonso said, 3 months, 3.5 months is not due process. It lacks due process. Giving the option to subpoena, witnesses, well, it takes longer than, a couple weeks, right? So being able to really, dive a little bit deep into both sides, slow the process down, and make sure that this is a wise decision for all parties is something that I think San Mateo County deserves. The report is flawed, and Christina Corpus deserves to, confront some of the people that are accusing her.
Thank you. Our next speaker is 52FGK9, followed by iPhone. 52, please unmute and begin. You're unmuted at this time. You can go ahead and begin speaking. We're not getting any audio, so I'll go ahead and go to the next speaker and come back to you to see if you've resolved that. iPhone, please unmute and begin.
Good afternoon. My name is Joaquin Jimenez, Half Moon Bay, and I'm calling. I'm very concerned about what's going on in San Mateo County. I don't know if you follow. Last week on Saturday, we had a large demonstration of thousands of people that came out to protest, to protect our democracy. And I'm very concerned and disappointed in San Mateo County. Only 20% of the population in San Mateo County voted, on Measure A. And that's something, that's setting a precedent, like it was mentioned, about our elected officials, giving the power to the county supervisors to remove Christina Corpus, who was elected by the people. She was not appointed by any of you. What happened to, our democracy? What's going on to protecting our civil rights to vote and decide who's going to be representing us? So just think about, our democracy and protecting our democracy. Thank you.
Thank you. And now back to our last speaker, 52 FK. Please unmute and begin. Still no sound, though you're unmuted, 52. And still no audio. I see you trying to mute and unmute, but there's no sound coming out on our end. Mr. President, I defer.
Sherry, can you try one more time for online public comment? Is there anyone else on there that we might have missed?
Sure. At this time, I'll take a final call, please, for item number 7 on the draft procedures for removal. Please click raise hand on Zoom if you'd like to comment. And 52 still has hand raised with the microphone unmuted, but there's no sound coming out.
Okay. All right. Thank you very much. Appreciate all the public comments. Do you have any colleagues have questions or comments? Start. Does anyone have any questions or comments? Supervisor Corso.
Thank you. I want to reiterate, as I've said before, that being here is not something that I think anyone ever wanted, but I do think it's important that we respect the will of the voters and move forward with hearing. Well, we've already heard the proposed process. I do personally think that it is a strong and fair process. It's been a long, hard road, I think, for everyone involved. And these next steps, I think, afford fairness to our county and to everyone involved. I also want to thank the county attorney and staff and Mr. Estrada for all of their hard work in doing the difficult work of navigating uncharted waters. This is unprecedented, I would say, and that's not easy to navigate or to it's not easy to show strong leadership in these kinds of situations. I want to thank the voters for entrusting the board. Their voices were heard loudly in this election, and I think this board will continue to maintain the trust that the county residents have put in us. And I know that it's been kind of difficult for people in our community to be unclear on what next steps would be exactly. And so I think this information that has been presented today is really important. And moving forward, I want to, you know, state that due process and fairness is something that I see as one of my core values and what informs my leadership. I'm really grateful that this process is in line with that. It's solid, it's transparent, and it's fair. And so I do think that I want to make clear that I support this process, and I think our community will as well. And that's it. Thank you.
Are there any comments or questions?
So,
Yes.
Mr. President, I just wanted to recap what I think next actions will be, and I want to thank Supervisor Corza for the comments. We, are going to, take we've got the benefit of board direction and feedback, having heard from the public. Mr. Mizuko had indicated a desire to meet with us, and we certainly will do that. Just sort of, again, with the benefit of the input that we've received here, bring at a future board meeting date some revised procedures that, again, reflect the feedback that we've received and the direction we've received, and any additional things that occur to us that we think make good sense for the board to consider. And so, again, at a future board meeting, we'll bring these procedures for your adoption. And then from there, we'll, of course, look to the board for further guidance with respect to next steps thereafter. And, of course, I also want to take the opportunity to thank Mr. Estrada and his team for their assistance in this process. But we again, we'll do some more work and come back to you.
Great. Thank you very much. Mr. Estrada, can you tell us a little bit, just for the public's knowledge, your background? I think it's really important to just kind of speak to your background and what you've done over your career.
Sure thing, Supervisor. So I think a big part of the reason I was brought into this process and to developing these procedures was because of my background. I started off my career as a prosecutor actually here in LA County. And then thereafter, I actually went to a union side firm that represented law enforcement unions. And then thereafter switched over to management side. And I've been working in that world ever since. I've handled hundreds of peace officer disciplinary cases, both on the union side and on management side. So I have a pretty deep understanding of due process, of POBAR, of all the really important things that need to be taken into consideration when developing these procedures and affording both the sheriff and the county due process. And I have zero reservation or doubt that what we've constructed is exactly that. So thank you, Supervisor, for asking me to share that, because this area of law is my life's work. And I take it very seriously, and I'm very proud of the work we did for the county.
Great, thank you very much. Through the county attorney, can you speak a little to if the public wants to be informed and educated on this process? Is there a website? Is there a place they could go, or is it just through our agendas? What are we doing to make sure that we're informing the public on what is going on? Is there?
What a great question. Yeah, the short answer is currently the response would be that it's through the agendas and the documents that we've posted in connection with agendized items. But it is good food for thought for us. Is it appropriate for us maybe to have a more accessible place where folks can go, where everything is? Again, it's of course our practice would be to, if we're going to do something like that, just to have it there in an without comment or without commentary, but just so it's available for folks to see. We can certainly work on that if that's something the board would like us to spend a little time on, is figuring out, again, a portal or something where people can go to find this stuff and be up to date on kind of where we are in the process.
Great, thank you very much. This was an informational item. I want to thank our public speakers for speaking, and we're going to conclude. We're going to, through County Council, do we have anything to report out on?
Would
I know the public but respond to a question you asked Mr. Estrada.
Okay.
I'd like to
Hold.
respond to what
Hold on one sec. Hold on one sec. Go ahead.
Okay. Well, a couple things I was going to say. If we were going to go to, if we wanted to change the order of the agenda so that we were going to do closed session at during the lunch hour, I'd probably want to entertain a motion to reorder the agenda to do closed session during the break that we're about to take. And there would, to my knowledge, be nothing to report out.
Okay.
But we can always determine that after a conversation in closed session.
I'm going to give you 20 seconds. 20 seconds, Mr. Mizuko. 20 seconds. Real quick.
Thank you. In response to Mr. Estrada, our group that's representing the sheriff, I was a federal prosecutor for 10 years, an assistant DA in San Francisco for 10 years. But for the last 12 and a half years, I presided over every disciplinary case for the San Francisco Police Department. And the attorney in this case, Jim Lessart, most of the cases cited by Mr. Estrada were argued by James Lessart.
Thank you very much.
Thank you.
Thank you. All right. With that, are we reporting out? I don't think we are we?
Well, we're going to come back in any event. So, but I would again ask for a motion to change the order of the agenda if again the intent is to do closed session during our lunch break here.
So moved. Do you need more words than that?
Nope. Just a second, and then a vote.
All those in favor?
Yes.
Okay. Aye.
Okay.
It's unanimous then.
Yes, that's unanimous. And the board, the time is now 11 p.m. and the board is currently in recess.